As we conclude this course, we now bring together everything we have discussed, from contracts and disclosure to encumbrances, easements, licenses, liens, encroachments, and water rights, into a final, comprehensive understanding of how property rights are shaped, limited, and constantly evolving. This final section builds directly on the previous discussion of water rights and expands into how law, nature, and government regulation intersect to define property ownership in the real world. At this point, one thing should be clear. Real estate is not just about buying and selling property. It is about understanding the legal framework that controls it. Modern water law, evolving beyond traditional rights. Historically, riparian and littoral rights governed how property owners used water. However, modern water law has evolved significantly due to population growth, environmental concerns, and resource scarcity. In some cases, these traditional rights are limited, modified, or replaced entirely by state-controlled systems. For example, states now have broad authority to recognize, or even refuse to recognize, riparian and littoral rights. This reflects the increasing need to manage water as a scarce and valuable resource. This ties directly back to earlier discussions on land use control. Just as zoning regulates land, modern water law regulates access to and use of water. Prior appropriation, first in time, first in right. In many Western states, including Arizona, water rights are governed by the doctrine of prior appropriation. This system is based on the principle of first in time, first in right, meaning the first person to claim and use water has priority over later users. Unlike riparian rights, appropriation rights are not tied to land ownership. They can be bought, sold, or transferred independently. This is a critical distinction and reinforces a key concept from earlier sections. Some rights are attached to land, while others function as separate property interests. Avulsion and natural changes to land. Beyond legal rights, nature itself can alter property boundaries. Avulsion refers to the sudden gain or loss of land due to natural events such as flooding, earthquakes, or shifts in a river's course. This concept builds on earlier discussions of encroachments and boundary issues but introduces a new element, forces beyond human control. Closely related concepts include accretion, reliction, and erosion. Accretion is the gradual buildup of land through deposits of soil or sediment, often considered a benefit to property owners. Reliction occurs when water recedes, exposing additional land. Erosion, on the other hand, results in the gradual or sudden loss of land. An important legal distinction is that land lost through avulsion does not change property boundaries, while gradual changes like erosion may. This reinforces a key takeaway. Property boundaries are not always static. They can change over time due to both legal and natural factors, environmental regulations, and building controls. In addition to natural forces, government regulations play a major role in how property can be used and developed. Building codes, zoning laws, and environmental regulations all impose requirements on property owners. For example, construction near shorelines may be subject to additional restrictions designed to protect ecosystems and prevent environmental damage. At the federal level, laws such as the National Environmental Policy Act, NEPA, require environmental review processes before certain developments can proceed. This ties directly back to earlier discussions on disclosure and due diligence. Buyers and agents must understand that regulatory compliance is not optional. It is a fundamental part of property ownership. The big picture, what really matters. Throughout this course, we have followed the life cycle of a real estate transaction and the legal environment surrounding it. We started with contracts and agency relationships, ensuring that transactions are legally enforceable. We moved into disclosure, emphasizing the duty to communicate material facts and protect clients. We explored distressed property situations such as foreclosure, highlighting the importance of timing, title, and financial obligations. We then examined encumbrances, easements, licenses, liens, and encroachments, each showing how ownership can be limited or shared. Finally, we addressed water rights, environmental laws, and natural changes to land, demonstrating that ownership is influenced not only by law, but also by nature and public policy. Final takeaway for the modern real estate professional. The modern real estate professional must operate at a higher level than ever before. You are not just facilitating transactions. You are guiding clients through a complex legal landscape that includes contracts, disclosures, property rights, environmental regulations, and risk management. Every transaction carries potential legal consequences. Every property has unique characteristics and limitations. Your role is to identify those issues, communicate them clearly, and protect your client while staying compliant with Arizona law and professional standards. What really matters is this: knowledge, diligence, and communication are your greatest tools in protecting your client, your transaction, and your license. Online discussion. Why has modern water law shifted away from traditional riparian rights in many areas? Answer: because increasing population and limited water resources require stricter regulation and management by the state. How can natural events like erosion and avulsion impact property ownership? Answer: they can change the physical size or boundaries of land, sometimes altering ownership rights depending on the type of change. Why are environmental regulations important in real estate transactions? Answer: because they control how property can be developed and used, ensuring compliance with laws that protect public health and the environment.